Hello friends, class chapter 10th Amendment of the Constitutions. Like any other written constitution, of the Constitution of India also provides for its amendment in order to adjust itself to the changing conditions and the needs. However, the procedures laid down for the amendment is the neither as easy as in Britain nor as difficult as in USA. In other words, the Indian Constitution is neither flexible and nor rigid, but the synthesis of the both. The Article 368 in Part 20 of the Constitution deals with the powers of the Parliament to amend the constitution and its procedure. Its state that the parliament may in exercise of its constituent power amend by the any law addition variation or the repeal any provision of the constitution in the accordance with the procedure laid down for the purpose. However, the parliament can't amend those provisions which form the basic structure of the constitution. This was the ruled by the Supreme Court in the Keswananda Bharati case 1973. The procedure for the amendment. The procedure for amendment of the constitution is laid down in Article 368 is as follow. First, an amendment of the constitution can be initiated only by the introduction of a bill for the purpose in the either house of parliament and not in the state legislature. Second, the bill can be introduced either by a ministers or by a private member and does not require prior permission of the president. 3. The bill must be passed in the each houses by a special majority. That is the majority of the total membership of the house and a majority of the 2/3 of the member of the house present and voting. 4. Each house must pass the bill separately in the case of the disagreement between the two houses. There is no provision for the holding a joint sitting of the two houses for the purpose of the deliberation and the passage of the bills. Fifth, if the bill seeks to amend the federal provision of the constitution, it must also be ratified by the legislature of the half of the state by the simple majority, that is the majority of the members of the house present and voting. Sixth, after dual passes by the both houses of the parliament and the ratified by the state legislature where necessary, the bill is the presented to the president for assent. Seventh, the president must give his assent to the bill. He can neither withdraw his assent to the bill nor return the bill from the reconsideration of the parliament. 8. After the president's assent, the bill become an act. The Constitutional Amendment Act and the Constitution stands amended in the accordance with the term of the act. Types of the amendment. Article 368 provides for the two types of the amendment, that is the special majority of the parliament and also through the ratification of the half of the states by the simple majority. But some of the other articles provide for the amendment and the certain provision of the constitution by a simple majority of the parliament, that is a majority of the amendments of the each houses present and voting, similar to the ordinary legislative process, not barely These amendments are not deemed to be the amendments of the Constitution for the purpose of the Article 368. Therefore, the Constitution can be amended in the three ways. A. The amendment by the simple majority of the Parliament. B. Amendment by the special majority of the Parliament. C. Amendment by the special majority of the Parliament and ratification of the half of the state legislature. By simple majority of Parliament. A number of the provision in the Constitution can be amended by the simple majority of the two houses of Parliament outside the scope of Article 368. These provisions include A. Admission or the establishment of new estate. B. Second, formation of new estate and the alternation of the areas, boundaries or name of the existing estates. Third, abolition of the creation of legislative council in state. Fourth, second schedules, emoluments, allocation, privileges, and so on the president and governors and speakers, judges, etc. Fifth, quorum in the parliament. Sixth, salary and allocation of the members of parliament. Seventh, rules of the procedure in parliament. Eighth, the privileges of the parliament. It's a member and it's the committee. Ninth, use of the English language in parliament. 10th, number of the personage judges in the Supreme Court. 11th, conferment of the more jurisdiction on the Supreme Court. 12th, use of the official language. 13. The citizenship acquisition and the termination. 14th. Elections to the parliament, state legislature. 15th. The delimitation of the constituencies. 6th. Union territories. 17th. The 5th. Schedules and administration of the schedules areas and the scheduled tribes. 18th. And the 16th schedule. Sixth schedule, administration of the tribal areas. By a special majority. The majority of the provision in the Constitution need to amend by the special majority of the Parliament. That is the majority of the total membership of the each houses and the majority of the 2/3 of the members of each houses present and voting. The expression total membership of the means the total number of the members comprises the house irrespective of fact whether there are vacancy or the absentees. The strictly speaking and the special majority is required only for voting at the third reading stage of the bill but by way of the absent because occasions the requirement of the special majority has been provided for the rules of the House in respect of all the effective stage of the bills. The provision which can be amended by the way include A. Fundamental rights. Second, directive principle of state policy. Third, all other provision which are not being conveyed by the first and the third categories by a special majority of parliament and consent of the state. Those provisions of the constitution which are related to the federal structure of the policy can be amended by the special majority of the parliament and also with the consent of the half of the state legislature by the simple majority. If once or the some or all the remaining state takes one action on their bill, it does not matter that the moment half of the state gives there the consent and the formality is the complicated. There is no time limit within the which the state should give there the consent to the bill. The following provision can be amended in the way First, election of the president and its manner. Second, extent of the executive power of the union and state. Third, the Supreme Court and the High Court. Fourth, the distribution of the legislative power between union and state. Fifth, goods and the service tax council. Sixth, any of the list in the seventh schedule. Seventh, the representation of the state in parliament. Eighth, the power of the parliament to amend the constitution and its the procedure articles as 368 itself. Criticism of the amendments and procedures. The critics have been criticized by the amendment procedure of the Constitution on the following grounds. A. There is no provision for the special body like the Constitutional Convention as a USA or the Constitutional Assembly for the amending the Constitution. The constituent power is vested in the Parliament and only in the few cases in the state legislature. Second, the power is the initiated and amended to the constitution lies in with the parliament. Hence, unlike the USA, the state legislature can't initiate any bill or the proposal for the amending the constitution except in the one case, that is the passing a resolution requesting the parliament for the creation or the abolition of the legislative council in the states. Here also the parliament can either approve the disapproval such as the resolution or may not take any action on it. Third, the major part of the constitution can be the amended by the parliament along either by the special majority or by a simple majority. Only in the few cases the consent of the state legislature is required, and that too only half of them, which while in the USA it is 3/4 of the state. Fourth, the constitution does not the prescribe the time frame within which is the state legislature should ratify the reject and the amendment submitted to them. Also, it is salient on the issue whether the state can withdraw their approval after the according to the same. Fifth, there is no provision for the holding a joint sitting of the both of the houses. The parliament, it there is a deadlock over the passage of the constitutional amendment bill. On the other hand, the provision for the joint sitting is the made in the case of the ordinary bill. 6. The process of the amendment is similar to the legislative process except for the special majority. The constitutional amendment bill are passed by the parliament in the same way as the ordinary bill. 7. The provision relating to the amendment procedure are too exquisite. Hence, the heavy of the wide scope of the talking the matters of the judiciary. Despite this defeats, it can't be the denied that is the process and the approved to the similar, simple and the easy and has the case in the meeting the change the need of the condition. The procedure is not too flexible as follow the ruling parties to change its according to their vision, for it is rigid and the incapable of the adapting itself to the changing needs. It as the rightly said by the K.C. Weser, strikes a good balance between the flexibility and rigidity in this context. The Pandit Jawaharlal Nehru said in the Constituent Assembly, while he wanted this constitution to be the solid and the permanent as we can make, there is no permanence in the constitution. There should be the certain flexibility. If the make any constitution rigid and the permanent, the you stop the nation growth and the growth of a living vital organic and the peoples. Similarly, Dr. B.R. Ambedkar observed the Constituent Assembly that their assembly has not only the refrained from the putting a seal of the as finally the infallibility upon the Constitution by the denying the people and the right to amend the Constitution as the Canada or any making the amendment of the Constitution subject to the fulfillment of the extraordinary term and the condition as the America or Australia, but has the provided for the facial procedure of the amendment there the Constitution. Casey, where has the admired the variety of the amendment procedure contained in the Constitution of India. He said this variety in the amendment process is wise but the nearly found. According to the Granville Astins, the amendment the process was the proved itself one of the most ably convinced the aspect of the Constitution. Although the appears the complicated, it is the merely advisors subscribe.